everyone. Look at that. Bobby, take a photo, check my out. No. Come on. Come on, good. What is couple of years ago. He died. Why did he really die?
Okay. Wait, oh, look at this. 5 of you. I don't know what to do with myself. 5 of you. Come on, 2. All right.
You're used to like 2. You're used to like 2.
I'm used to 2, maybe 3. That's all right. I mean, I can talk to 1. So, first I want to kind of do some introductions. So, you guys know each other, but I don't know you. And oh, it's showing up there, but not here. Okay, so well, it's a post-it. Sign. Well, let me just ask you, what I want is to know first why you're in law school. That's the first question, and you might think that that's like a no-brainer answer, but it's not really. So I want to know why you guys are in law school, what you expect to, just hold on just a second to make sure. I'll have to fix that on the way. Okay, so, and Simon's here, this was working.
It's not here. Going together?
It's showing up online, but it's not showing up here.
Okay.
Yeah, please. And we went through this. We got here early. So we can do this. I always get here early. And now. Side.
Yes, ma'am.
So now something's not working here. It's moving here, but it wouldn't move. It's moving on my computer, but it wasn't moving up there. See, it's even showing there, but not here. So I'm not sure what's happening here. Yes, absolutely. It's, okay. So while he's doing that, again, my questions are, I want to know your name. I want to know why you're in law school. I want to know what your end goal is. And don't think that's a simple question either, or an easy answer, because sometimes people go to law school and they don't want to be lawyers. They want to do some other things. So I want to know what your end goal is. And what other question here? Oh, and what area do you think you might be interested in? And if so, why? So, who's first? Okay.
I'll go.
Hello. Okay, thank you.
My name's Daniel Caliendo. I have been out in the desert for 3.5 years. I'm from Boston originally. And why I came to law school, let's see. I guess I don't want to give a cliche answer of I want to help people, because I do want to help people, but that's not the reason that I went to law school. I think a lot of people are self-interested, so I think I'd fall in that category.
It's okay, you can be honest.
Yeah,
Right
I'm going
here.
to be honest about it. I'm not going to beat around the bush and say I just want to help people. I do want to help people and be of service. That's a big part of my life today. However, I'm really about keeping options open and doors open, and I figured law school was kind of one of the best ways to do that. I knew from, a pretty young age anyways, maybe since I was about 20, I'm 27 now, that I wanted to go to law school. And I started working for a personal injury firm in Boston. And actually before that, right after I graduated, I was walking in Boston Common and I started just talking with this guy about hockey, and he was in a suit, and started talking about what I'm doing, what he's doing, what he does for work, and he ended up working for a firm. And I told him I was graduating with a BA in international relations, and I was actually looking for a job at a law firm. And so he asked me if I wanted to come in and interview, so I did, and I ended up working there for the next couple of years. But I think from that point on, really towards the end of college, I kind of knew that I wanted to go to law school. I just didn't know when. But I wanted to get some practical experience, and my degree had nothing to do with law, right? I mean,
What was your degree?
International relations, so like international politics, which is in the ballpark, but so I figured the best way was to get experience in a personal injury firm, right? So I started working for this personal injury firm, and it was really, really good experience. But I guess I've had so many ideas of kind of which path I wanted to go down. So I got exposed to personal injury law, which I definitely have an interest in. But I can say that almost about any field of law. I think the only one that kind of scared me away was family law because of the emotion that's involved in it. I know Brian's got a lot of experience in family law now, so he can tell me. But if you really want to have an impact, it's a great area. It's a great area of law, and you can make a good deal of money doing so by listening to people's problems. I haven't been exposed to criminal law too much yet. I'm looking to get hopefully some trial experience maybe in the next year or so with John to see if I want to rule that out. Right now I work as a paralegal, so I work for the legal department, but of a private corporation. So we deal with all civil litigation, like trade secrets, medical malpractice, because it's a medical staffing company. And then, just the regular breach of contract, collection suits, on like delinquent accounts. So just stuff like that, but I manage all the legal stuff. So that's actually a lot more interesting than I thought it was going to be. Even the trade secret stuff, very interesting. So I haven't really decided what I want to do yet, and there's so many doors, and it seems like everything's pretty much of interest to me. I heard Indian law.
That's wonderful, actually.
Yeah, it is, because I'm all about keeping doors open.
You're like a sponge. And I think that's great. It's a great place to be right now.
Yeah, I think what will probably end up happening is if I end up going out on my own, I'm not sure yet. I know I want to get trial experience right off the bat because I want to get comfortable doing something that's going to be uncomfortable at first. So I want to dive in both feet. I'm not even sure I want to be a litigator in court.
I'm going to move us along though.
Oh, absolutely.
Yeah. But thank you.
Yeah, of course.
Thank you.
Okay, so my name is Isabel Torres. Why law school? I think that was just cemented in my brain when I was like in fourth grade. So they said, "Oh, you'd be a good attorney." But by the time I hit college, I think I had second doubts, and I wanted to go take journalism or something. And so I had a speaker come in, and they worked with attorneys who did immigration and civil rights, and they talked about the impact that they had on people, and I felt like that really spoke with me. And then I'm from the Valley, I grew up here, so I felt that that was an avenue in which I could give back to my community. I know there's a lot of people in my family who have immigration issues, so it was something that hit closer to home. So that's really what's driven me through law school up to this point. As for my end goal, I want to do immigration law. At this point, I know I want to do another field of law with immigration law. I'm just not sure what I want to do. I currently work here with John, so I've seen a lot of criminal defense. I don't know if I want to do that. I've gone 2 trials with him. I've done a murder, a rape case, and it's very difficult, and I don't think I want to do that day in and day out. So keeping my mind open to as to what other fields of law I want to do.
And I hope you didn't take that personally.
Oh, no,
I
not
just
at all,
needed
not
to
at
move
all.
us along, so.
I ramble a lot.
But
try not to.
okay.
I
So
gotta
thank
reel
you
it
for
in.
letting me know that now, okay. Okay, because I'm gonna, I want you guys to participate. That's actually really important here, but I'll have to keep us moving.
For sure.
Alyssa?
So I'm Melissa Chavez. I'm actually new to their group. I'm from the class, the 4L class. I took a year off last year and returned this year. Why I'm in law school, I've been a paralegal for about 7 years now, worked in every area of the law. Wanted to do it for family law because I've come across a lot of obviously people that have suffered a lot of crimes that I want to help. But recently that switched over to immigration. That could have something to do with me being Puerto Rican and from El Paso, Texas. I don't really like what's going on right now, so I figured to be able to change it, I've got to be changing it from within. So that's basically why I'm here, and right now I'm actually trying to move up from family law, where I work, to paralegal and immigration as well, so that I can be a little bit closer to that goal. So, favorite class? Probably contracts.
What?
I loved it. Loved the structure.
Well, good.
Loved the way it read, and just that was my favorite. I did really well in that.
Hey guys, I'm Brian.
I forgot you guys all stand. You don't have to stand in here. Let me just say that. You do not have to.
The eyes are watching. We do get up.
No, you don't. I'm telling you in this class, you do not have to. So unless you just feel like it, you can feel free, but you do not have to. I'm not requiring that. So, yeah, because I'm not standing, so.
She gave me the chance. I'm Brian Agbani. We start off from the bottom. My favorite class was criminal. I think I was drawn to law because it's both very scary and at the same time fulfilling. And wherever you go, it's you can change lives. And I didn't think me changing lives as a doctor, medical field or engineering wasn't best for me. When I hated math and science. So I thought I needed to do something that I could probably be good at. And reading, arguing, and writing was possibly something I was going to do, and law was my avenue. And law school has always been around. I tried to escape it. I tried to run away for like 5 years after I graduated, tried different things, but nothing about me. I actually worked in an IP law firm for a little bit, and it was very enjoyable. It's very competitive, especially if you work at Palo Alto. So that was pretty fun. But thus far, I'm drawn to family law because it's very fulfilling, drama-filled.
Which law?
Family law. I work with Michael Taylor, and it's very frustrating but very fulfilling once you're able to help people. And I've yet to delve into criminal law. I'm hoping to intern here, see how I can manage my schedule. So yeah.
Well, I think whatever area you go into, I really encourage you to find something that really interests you more than anything else, because honestly, in our profession, there are a lot of unhappy people. And many of them do things because they feel like they have to. And I get to see on the other side what happens when when people are doing what they don't really want to do. My name is Francine Ward, and I'm sure you guys have already looked me up. I've been practicing law for 28 years. New York was my first bar, California, then the District of Columbia. I went to Georgetown, as again, you probably know. And I've been in the desert. We've had a house here for 10 years. We were in the Bay Area up until recently. Now I'm actually a permanent resident. Oh, I forgot, Trish, I'll get you. I forget, so you have to remind me. We will get you in just a moment. What was I saying? Oh, so now I'm a permanent resident of the desert. My husband and I am married. I have 2 cats, and that's my family. And I've been doing intellectual property law for, I don't even really know right now. It's been many years. And I got into it sort of by accident. Actually, it's interesting. I was grateful when you were telling the truth about your reasoning. When I first decided to be a lawyer, I used to tell people I was doing this because I wanted to make a difference. I'm sure that was part of it, but in my case, I actually became a lawyer because I needed to prove I had a brain. I wanted to be a doctor at first for that reason, but I'm afraid of blood, starting with my own. And the idea of cutting animals up is so appalling to me. I have animals. I just said, no way. So the only, the next best profession to prove I was smart was law. So I do help people though. It's really a significant portion of what my life mission is all about. But it wasn't my main reason for going into it. But today, actually, I do a lot of pro bono work. I'm a big believer in giving back. I think to those of us who've been given much, we have a responsibility to give back. And I really do believe that. For years, I did pro bono and family law, and honestly, family law is not my cup of tea, mostly because it's so emotional and it's so heartbreaking. Because every now and then you'll see success stories, but for the most part, there are a lot of broken families. Children always get caught in the crossfire, and that for me is quite unfortunate. But I love what I do. I absolutely love intellectual property. I also do wills and trusts, but my primary focus is IP. I do copyrights, trademarks, publishing, entertainment, and social media. That is my primary focus, and I love it. And it's the greatest time in the world to be an IP lawyer because it impacts everything we do, literally everything we do. Pretty much every contract has IP implications, and from the devices we use to social media to just anything on the internet, it involves intellectual property. So it's a great time. And who knows, maybe one of you may decide this is an area that you find interesting. And what we're going to do here is it's going to be an overview of the topics. But before I get into that, Trish, let me let you introduce yourself. Can you hear me?
Hear me?
Hi, can you hear
Can
me?
you hear me?
Are you able to hear me when I'm talking?
I can hear you, yeah.
Okay.
Can you hear me?
Yes.
Okay. I decided I wanted to be a lawyer. It was something that interested me for a long time, but it just never presented itself as a possibility because of the cost. And so when the California Desert Trial Academy came into play, I was really excited to do that. And initially, I wanted to be a prosecutor because I had covered some trials before in my previous career, and I thought that was just fascinating to be in the courtroom all day. But I also was surprised how much I loved all the other courses as well. So I've been in the healthcare industry for about 10 years now, and I really like that. So I work for a clinical research organization right now in Carlsbad. And so, I'm interested in all types of law. Whatever presents itself to me would probably be of interest.
Good. Good. Well, welcome. Now, do you live out of the area? Is that why you're doing distance learning? Or is it just tonight?
No. I will be there normally on Tuesdays and Wednesdays, but I sprained my ankle about a week and a half ago.
Oh.
And so it's just hard to get around. And so, but I will be there next week. But I do work in Carlsbad on Mondays, Thursdays, and Fridays, so I do commute quite a bit.
I'm sorry, I didn't hear the last thing she said.
She does commute quite a bit.
I do in Carlsbad. Mondays, Thursdays.
Oh, okay. Oh, in Carlsbad, wow. That's a long commute. Well, I'm glad you're here, welcome.
Yeah, thank you.
So we have an 8-week course, and we are on Tuesday now. They switched me from Wednesday to Tuesday. And the makeup of the class is going to be, first there's some things that I want you to be aware of. First, as you know, this is pass-fail. But just because it's pass-fail doesn't mean you can't do the work. I'm not grading the same way as the others, but again, there is work here. And mostly, what it really involves is, let me just open the book. It's going to be participation. I want you to participate. I do not want, this class is so small, I can't be doing all the talking. And I already know what I sound like. So I don't want to do all the talking. I want you to engage. I want you to disagree. You're going to find some of the things we'll talk about, you might think, well, wait a second, that doesn't sound right to me. I don't like that. And I want you to be able to tell me why. So I want you to disagree. I'm not one of those people who only thinks you should be agreeing with me, because in my life, nobody does. So I want you to be able to do that. I want you to comment. I want you to engage. The other thing that's really important is that you show up. Again, we only have 8 weeks, so I want you to show up, and I'm a big believer in being on time. I'm gonna be on time, I expect you to be on time. That includes coming back from breaks. I will almost always let you out early. I can't remember when we stayed till the end. I think maybe the day we did the tests, I don't know. But like most of the other classes, you'll get out early. I think usually it's around 9, maybe even earlier. But for that, I definitely want you to be here on time at 6, and I want you to come back when I want you back for break. And this class, unlike your other classes, at least the way I remember law school, it's not going to be intensive when it comes to the cases. What I'm going to do is I'm going to show you, we're going to use some cases, but they're going to be brief descriptions, basically to help you understand what some practical aspect of that case is. So, and I think that's it. Any questions before we kind of get started? Oh, let me say one more thing. So the way the class is going to be broken up, today and next week, it's going to be copyrights, 2 classes for copyrights, 2 classes for trademarks, 1/2 of a class for patents, which is my least favorite. Sorry for those of you that are interested in patents. There'll be 1/2 a class for patents, and I think the way I've done it, let me just see, I think the way I broke it up is trade secrets and patents will be the 5th class. Yeah, trade secrets and patents will be 5th. And then I believe the 6th class is going to be right of publicity and 1/2 of social media. And then social media and advertising law will be the 7th class. I think that's what I put down. And then the 8th class is going to be contract drafting and then the exam. So the exam is going to be, you will pass this exam, honestly. If you are in this class participating, the exam you're going to pass. It's going to be basically a fact pattern, and it's going to be issue spotting, which you guys already know how to do, and it's not going to be complicated. So I'm not here to make your lives difficult. I'm really here to get somebody interested in intellectual property. That is my goal, honestly. So I'm not going to make it too hard for you, but I do want you to pay attention. And I chose the book. This is an easier book for us to work through, as opposed to the first year I have another book, which is big and fat, and that was, unless you're really interested in IP, that's not a book for you. So, any questions right now about anything having to do? Yeah? Okay. Question, Trish? Yeah? Okay. So intellectual property, what is it? Intellectual property is a bundle of rights. That's the way I kind of like to think of it. It's a bundle of 5 different types of rights. And think of it like this. Let's say you go to a supermarket and you're buying some fruit. So you're picking up apples, oranges, bananas, mangoes, and kiwis. You put them all in your basket. Those are all different types of fruit, but each one is distinctly different. They taste different, they look different, they feel different, they impact your body differently. That's how it is with intellectual property. It consists of a bundle of 5 different types of rights: copyrights, trademarks, patents, rights of publicity, and trade secrets. So when somebody's talking about intellectual property, that's what they're talking about, one of those 5 types of rights: copyrights, trademarks, patents, rights of publicity, and trade secrets. Again, our focus tonight is going to be on copyrights. Oh, I have the agenda afterward. Okay, there it is. So copyrights classes 1 and 2, trademarks, patents, rights of publicity, social media, and advertising. So what's a copyright? This is a basic, simple answer. It's an original work. It's legal protection for an original work of art or authorship reduced to a tangible format. Now, you might think this is really simple, but I'm going to tell you everything is going to hinge on this definition. an original work reduced to a tangible format. Here is actually what the statute says. And the statute, this is in Title 17 of the US Code. And Title 17, Section 102 says copyright protection subsists, that means it's, in accordance with this title in original works of authorship fixed in a tangible format. Now known or later known in any way that can be perceived, reproduced, or otherwise communicated. Again, the key here is original, reduced to a tangible format. That's going to become very, very important as we start looking at cases and as we start talking about what's protected and what's not. Original, reduced to a tangible format. Something that can be perceived, communicated, reproduced. And I am happy to send you guys this if you want. Let me give you my email actually, so you will also be able to email me if you have questions. So my email is, I think the one I included was info@fwordattorney.com. Yeah, and in the subject line, just say something like class, IP class. So I'll know, because I get so much junk, as you can imagine. So there are a number of categories that copyright falls under: literary, pictorial, artistic, musical. So these are the overall general categories that copyright, of things that can be protected by copyright. Literary works, musical works, and we're going to take a look at some examples within each of those. Dramatic works, pantomimes, choreographed works. But again, the key is it has to be something that's original, and it has to be something reduced to a tangible format. So let's take a look at some examples, some specific examples of what's protected. So photographs can be protected by copyright. Website content can be protected by copyright. Did you know that? Website content? So if someone's creating a website, as long, again, as it's original content, that can be protected by copyright. Yeah. Books, articles, things of that nature, that's part of what's literary. Webinar content. Speeches. But it's an interesting thing about speeches. I recently had someone come to me and they were very upset. They wanted to sue someone. People are very quick to say I want to sue until they realize how much it costs. They think all lawyers are going to pay for that up front. And no, it doesn't work that way, especially with copyright infringement, because it's so hard to actually prove. But someone came to me, they said, somebody stole my signature story. So I asked them, I said, well, did you record your talk? No. I said, did you have it transcribed? Was it written somewhere? No. I said, did anybody, videotape you while you were talking? No. I said, well, was it reduced to any kind of tangible format? No. So I said, you don't have copyright protection. Because again, original reduced to a tangible format. So for speech to be protected, it has to be in some way reduced. So somebody could record a talk, they could record them talking, they could transcribe that talk into a printed format, but it has to be reduced to a tangible form. Other things that are protected by copyright are ebooks, content of the ebook, scripts, movies, all kinds of things. Characters in some instances can be protected, not always, but sometimes. Harry Potter's protected. Mickey Mouse is protected, although Mickey Mouse is about to lose his protection. Donald Duck. Anybody remember Donald Duck? I forget. Oh, okay, good. Good. Sometimes I use examples, so you have to, kind of correct me. I forget, because I'm old, that my classes, most people are very young. So when I'm using an example, sometimes people look at me like, who is that? So just kind of shake me and say, who is that? So I can come up with another example. Jewelry. Jewelry is sometimes protected under the sculpture category, but again, it has to be original works. I have a client whose jewelry we protected years ago because it was that original. Other examples, music. So music falls into two categories, musical compositions and sound recordings. Does anyone know the difference between the two? Want to take a guess? Think about it for a moment.
The compositions are the notes on paper,
Sheet music.
sheet music.
Mm-hmm. And the sound recording would be,
The audio transcription,
what was that?
like the audio transcription of whatever was on the sheet.
Like, you guys all listen to music? How do you hear your music? How do you hear your music? Do you listen
Apple iTunes type of thing.
Okay, so it's a download,
Yeah, like an MP3.
or an MP3, yeah, or a CD, they don't have the CDs, and now even
YouTube.
the things I grew up with, like the
Walkman.
No,
the
the
vinyl.
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 Those are you right.
I know,
They're coming
It's
back.
kind of that.
I know, I can't believe it, I have all these 33 RPM records, I'm so grateful I saved them.
Everybody's into them.
On a turntable. Well, when I grew up in the 60s, we were using those things. No, nobody was born here then, right? No, you're 27, so definitely not. Okay. Anyway, so musical composition. So you've got the sound recording, the record, the MP3, the song that actually people listen to, and then you've got the sheet music. Both of those are protected, and they're protected separately. Which is why, quite interestingly, when someone wants to get permission to use music, and we're going to talk, Katy Perry just lost her lawsuit. We're going to talk about that next week. I think we're going to deal with that one. We're going to talk about infringement. But when someone is wanting to use music legally, they generally have to go and get permission from a number of people. Not only the songwriter, but the publisher. I mean, there are more than one people generally that's involved in giving permission for a song. So other things that are protected, PowerPoint slides, articles, marketing materials are protected. Again, keep in mind, original works of art or authorship reduced to a tangible format. Newsletters, I mean, there's so many things that are protected by copyright. One good way of thinking about this, let's say you have a book. So on the outside, the cover of the book, the title, if at all, it's going to be protected by a trademark. But inside of the book, you've got the contents. So everything inside of that book, as long as it's original, is protected by copyright. CDs, synchronized content, do you know what that is? So synchronized content, let's suppose I added music to my PowerPoint. That's synchronized content. Let's say I added some moving images. That would be synchronized content. Let's say you add, let's say you have pictures and you put them together and you turn them into like a slideshow. That would be synchronized content. So you're synchronizing two different types of formatting. Social media templates are protected by copyright. Workbooks, manuals, again, anything that's original works of art or authorship are protected by copyright. Blog posts, sound recordings, musical compositions. Copyrights also protect. And what I'm starting to say about the email, if you want me to send you this after we finish the copyright classes, I will. Just request it. Mm-hmm.
For blog posts, is that just like the journals where people are writing about a certain topic, or is it for, there's a lot of blogs on social media, just like random things, or does it have to be like a journal type blog?
It has to be original.
Just the original.
That's what it has to be. That's all. And the Copyright Act, I mean, it is so easy. The benchmark for creativity is very low.
Mm-hmm.
The key is original. So if someone's creating original content in their blogs,
Mhm.
then that could be protected by copyright. Screenplays, book proposals. My author clients, when they're preparing book proposals for a publisher or to get a publishing deal, I always have them register their proposal. Always. Why? Because people like to steal today. They do. Even agents. So I want to make sure their content's protected. And generally, a book proposal is going to include 2 sample chapters, so that's their original content. Virtual gaming platforms, choreographed content, pantomimes, those are all protected by copyright. Surveys, questionnaires, I mean, again, the list is endless. And I put up a list like this so you can start to think, you know, for those of you that might be interested in this area, if you've got clients that have any of this kind of content and it's original, you want them to be thinking protection. So what can't be protected by copyright? Ideas. Number one, ideas can never, ever, 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 ever be protected by copyright. Why not? Because ideas are a dime a dozen. And the truth is, there are not that many original ideas around. Think about how many movies you've ever seen where boy meets girl and lives happily ever after. Or boy meets girl and somebody wants to get in the way of them living happily ever after, and maybe one dies. Shakespeare. I mean, really, how many, you know, boy meets girl and lives happily ever after? All of
Nicholas Sparks.
who?
Nicholas Sparks.
Oh my god.
Who is that?
Nicholas Sparks.
Oh, Nicholas Sparks, The Notebook. He's got all those sweet movies, and I watch the Hallmark Channel. Every single one of them is boy meets girl. There's a little interruption, and then they live happily ever after. So again, if the idea itself was protected, I mean, we couldn't have all those Hallmark movies. Nicholas Sparks wouldn't be making all the money he makes. What was her name? Who was in Harry Met Sally? What was her name? The actress who was in all the like You Got Mail and
Oh, the blonde.
Meg Ryan.
Meg Ryan. All of her movies are like that, you know, boy meets girl and they live happily ever after. When I grew up, I was watching Rock Hudson and Doris Day. Boy meets girl. So again, the idea that ideas are never, ever, ever protectable. The expression of the ideas are, but not the idea itself. Processes, methods, systems are never protected by copyright. Ever, ever, ever. No matter what anybody tells you, the statute clearly tells us that processes, methods, and systems are never protected by copyright. If they're protected at all, they're protected by patent. If at all, it's going to be a patent. Likewise, slogans and book titles are never protected by copyright. Book titles especially are never protected by copyright. I had, a number of years ago, a potential client that came to me that literally stood me down. She came to me and said, Francine, I want you to register my book title as a copyright. I said, it's not possible. She said, yes, it is. She said, my friend registered her book. I said, no, she said, my book title. She said, no. I said, no, it's not possible. The statute says you can never, ever register a book title as a copyright. She says, but I know it can be done. So as I continued to listen to her, I realized she was confusing book title with book. Mm-hmm. So her friend registered her book with the Copyright Office, but the book title was not protected. If a book title is going to be protected at all, it's going to be through a trademark. But there are some exceptions, and we'll talk about that when we talk about trademarks. But a book title, if it's going to be protected, again, it's through trademark law, not copyright law. Same thing with slogans. Slogans like, just do it, you got mail, those things are protected by trademark, but not copyright. And again, oftentimes people misconstrue copyright with with patents and trademarks. Often I hear people say, they'll talk about a copyright when they really mean a trademark. Or they'll talk about a trademark when they're really meaning a patent. So that's why I'm really going through the distinction here, because they are different. Again, think of the fruit. Kiwis are different from mangoes, are different from apples, and bananas and pears. What else cannot be protected? Anything that's not reduced to a tangible format. So that goes back to the speech. If you give a talk and it's not recorded, then it's not protected, period. It is not protected. It must be protected. It must be recorded. So this is being recorded. This is protected, absolutely. And I've given this talk many times, and it's been recorded. But if it had never been recorded, although I've got it on paper, but that's different. That's different. The PowerPoint would be protected, but not the talk itself. So anything that's not tangible, non-original content. So for example, let's say Melissa, you write a book and it's all original content. It's clearly copyright protected work. And let's say that Isabel decides, well, I like a couple of your chapters. No, wait, no, you're Isabel.
You did it right.
No, Melissa.
You're
okay. Okay, I'm learning. Okay. And so let's say Isabel says, I like a couple of those chapters in your book. I'm gonna take a few of them and put them in my book. But then she tries to claim that she's got ownership in this work and that it's all her work. We're gonna talk about registration. If she tried to register it, the truth is the only part of her book that would be registerable would be her original content.
Not
And
the parts that she took.
Exactly, because it's not original. She can't claim copyright in that because, again, the definition, original works of art or authorship reduced to a tangible format. Original, fixed, original, fixed. Key pieces here. So non-original work cannot be protected by copyright. What else can't be? Again, short phrases, names can't be protected by copyright. Sometimes names are protected, but you know what they'd be protected under? Wanna take a guess? Of the five pieces of IP, that's it. Who said it?
She said it.
Yeah.
Well, who said it first?
Oh, okay, oh, it just went down the line, huh? You copied him and you copied him. Yeah, if a name is to be protected at all, and we'll talk about that with trademarks because there's several celebrities that have protected trademarks, like Madonna, Beyonce, their names are protected. Prince's name was protected by trademark. Tiger Woods, his name is protected. And we'll talk about why it's protected, not just because they have a name, but because they use it as a brand. Yes,
So
ma'am?
this is not the books or anything, but, so that's why when a photographer takes a photo of a celeb, one of those paparazzis, and then the celeb puts it on Instagram, and then later you see them take it down and they're like, oh, I just got hit by the photographer sending me this dumb message saying that if I don't take it down, they're gonna hit me with copyright infringement.
And who just got, one of the Kardashians just got sued for that shit to take something down. We're gonna talk about photographs, but that's right, that's exactly it.
Because
Because the
the
photographer-
photographer is originally one person that took it, so.
Because the photographer has the rights.
Even though it's up to them, it doesn't matter.
Yeah.
They didn't take the picture of themselves, so they can't claim it.
That's right. That's right.
Makes sense.
Again, procedures, methods, systems are not protected by copyright. Did you guys want to share something?
No, I just said how like this is like up my alley. This is like right up my alley.
Good.
Yeah.
I don't know either.
Not everyone is interested in it.
Well, I don't
You
know.
know, I get it. This is not family law, so not everybody's interested, so you'll just, it's only 8 weeks.
It's so interesting. Like I do family law too, but this is really interesting too. I mean, because
Well, this is just the beginning.
yeah, there you go.
Public domain works are not protected by copyright. So what's a public domain work? Technically, it's something that's in the public domain, which means anybody is free to use it. So what goes into the public domain? Well, works generally that have been created prior to 1923. Almost anything that's created prior to that time is free to use. And actually, there are some things that just went into the public domain at the beginning of the year. I wonder if it was Mickey Mouse, if he went in. There were, or it might have been Donald Duck. Several things have already gone into the public domain now. If it's in the public domain, you are free to use it, period. You don't have to ask permission. You don't have to worry about fair use. You are free to use it if it's in the public domain. The key is it really in the public domain?
So how does that work? Does it, like every year you climb a year, you know, in terms of like, once next year hits, you could start using things from 1924 and before, or is it just things
Yeah,
like,
in that case, but there are more things that go into the public domain. Here's some other things that don't even rely on the time frame. So like works that are not in a tangible format. Again, if it's not fixed in a tangible format, it's in the public domain. If it had no original content, it's in the public domain. If it lost its protection, so prior to 1989, the United States was not a signatory to the Berne Convention, which is a treaty. It's an international copyright treaty. And we joined it in '88, and it actually became official March 1st of 1989. You can look that up if you want. Once we joined the Berne Convention, we had to do what everyone else that was a signatory was doing. And one of the things was, up until that time, if your work didn't have copyright notice, and we're going to talk about that in a minute, usually it's a C in the circle you might see, but it's not just that. If a work did not have copyright notice prior to 1989, it was not protected. It lost its protection. It went into the public domain. The other thing that happened in 1989 when we entered the when we became a signatory for the Berne Convention is we had to register works. I'm getting ahead of myself. Bottom line is if something lost its protection due to it not being registered or it not having notice, it was in the public domain. Historical facts. Facts are not protected by copyright. So how might that show up? Let's say there's a newspaper article. Sometimes people think if it's a newspaper article, it's free to use. No, because the way the article was written, the way it was crafted, is some author's creative expression. So the expression was protected, but the facts are not. Does that make sense? So you can take the facts out of there, but you can't copy the way they've written that article. The way they've written it is protected, but the facts about whatever it is are not protected, especially if it's something that's of public knowledge. The other thing that's, that's in the public domain is most things. There are exceptions, but most things created by federal government employees. If it's created by the federal government, it is generally free for everyone to use. Now, again, I'd be clear. Not state governments, federal governments. So if you see something that's created by someone that works for the California state government in some way, don't assume that that's free for you to use. But federal government, yes.
Question. How would you draw the line for within scope of employment?
Good question.
Or?
Well, that is a litigated question. That is a litigated point always. How do you draw that line? So potentially it could be if someone is working for, let's say, the Securities and Exchange Commission, and they have to draft documents, SEC documents. That's within the scope of their employment. An argument could be made. Let's say on their free time, during their free time, they are drafting SEC forms, but it's on their free time. It's during their free time, and maybe they're doing it for a friend. They're helping a friend out. That's during their free time, but, they're doing the kind of work that they would be doing for the government. So again, that's a highly litigated topic. As for federal employees, I think it's not gonna be as big of an issue as it will be in some other areas. You know, when we're gonna talk about work for hire. But again, it's a highly litigated topic. You might wanna look up a case and see if you can find something dealing with public domain, employees, and within the scope of their employment. And then you can talk about that next week. That's a good assignment. Okay. So again, the key here is you wanna make sure, just because you think it's in the public domain, it might not be. So really, doing your due diligence is critical. Sometimes people think everything on the internet is in the public domain. No, that is not true. So you really wanna make sure before you start using someone's work. So let's take a look at some of these cases dealing with what time. What time do we break? Oh, 7:33. Some of these cases that deal with originality. So Feist, and I think Feist is in there. You might have read that, isn't it?
Mhm.
But I just briefly came up with a little description. So rural published a white page telephone directory for its 11 local Kansas area subscribers. Feist secured permission to use all of the information, the listings for the local telephone companies except for rural. So that's the only one that it did not get permission for. In fact, not only did it not have permission, but it used 1,300 of their listings illegally. They sued for copyright infringement, rural did. The lower court ruled in favor of rural, but the Supreme Court, and this is a major case for us in the copyright arena, the Supreme Court came back and said, nope, it reversed the lower courts. Why? Because of the originality factor. Because just listing names on a piece of paper or even in a book is not original. Does that make sense? Just list, and yet there have been cases where databases have been deemed protected by copyright because they were original. The way they put them together, the way the formatting was, the page, you know, again, originality is always going to be the key. And the bar is low. It's not like it's so high, but they want to see some level of creativity. And a telephone book with a list of names and numbers was not original. This went all the way up to the Supreme Court. And
Is there like a definition for original, or is it just kind of on a case by case basis where
so
they'll establish that?
I'm not sure how much you guys have, or which courses you've taken yet, but what you'll find, especially when it comes to case law, is it's all at the discretion of the court. And courts, each state, you know, interprets the law differently, and each circuit interprets the law differently. The Ninth Circuit, which many of our cases have been overturned by the Supreme Court, we interpret it a certain way. The Second Circuit, when it comes to IP law, the three big areas are New York, California, and actually Tennessee has a lot because Nashville's there, you know, and a lot of the music industry. So much of the law is in these three circuits, but mostly it's California and New York. It's the Ninth Circuit and the Second Circuit. They don't always agree. So it really depends on the whim of the jurist. And you can actually, you might want to, for your homework assignment, you can look up some cases. You can just Google. You guys have access to Westlaw or Lexis, don't you? So go in and put copyright infringement, originality. Look up the Ninth Circuit and just see what it says.
Okay.
Yeah. And you'll see, and then the creativity, and you'll see the level is so low, really, of what's considered creative. But take a look and you can come back and discuss a couple of them next week. Okay. Another one, Blystein. I don't know if this one is in there. Is it? I don't know, because I added some additional ones. So this one, Blystein hired Donaldson to produce promo lithographs for use in advertising his business. without any permission, Donaldson reproduced those lithographs and reduced them in size. Blystein sued for copyright infringement, of course, and Donaldson asserted that those lithographs were for advertising purposes and therefore not protected. Well, the court came back, and this also went to the Supreme Court. The court came back and said, absolutely, they're protected. We can't determine what's creative and not, what's really artistic and not. So again, this goes back to those marketing materials. Marketing materials, advertising pieces are absolutely protected by copyright as long as they're original works of art. That's why when my clients come to me and they want to, and most of my clients are businesses that are creating brands, or they're authors, or some individual, some creative individual. But when the businesses come to me and they want to hire people to design their websites, design their marketing materials, we want to make sure they have agreements in place. Why? Because if they don't, and we'll talk about it in a minute with work for hire, the person who's creating the work is the one who owns the copyright, if they're an independent contractor. So we want to make sure, I want to make sure my clients own the work, but we'll talk about that in a minute. We're going to get to work for hire.
So every case, not basically, but the majority of cases start there. You have to prove that the work was original and then build on who stole it, if they stole it, but it all starts building on, you have to prove
if there's a copyrightable work.
That it's
Absolutely.
first original.
And next week, we're going to purely focus on infringement. What's required for an infringement case? How do you build that case? There has to be a copyrightable work. You have to prove substantial similarity. There's certain things that the courts are looking at. Yeah. But you're right, it's like a building block. But it starts with, is it original and is it in a fixed format? Number one, it has to be that. Is it copyrightable content? And even if it's original content, not everything is copyrightable. There's some things that just aren't. I love this stuff. Another case, and again, I'm not sure which ones are in the book, but Burroughs, Giles, Sarani, a photographer, took a photo. Speaking of photographs, again, this is about the protection of photographs. Took a photograph of Oscar Wilde and secured a copyright in the photograph. Again, the photograph is the issue here. Burroughs sold copies of the photo without permission. The plaintiff sued for copyright infringement, and in affirming the lower court's decisions, another Supreme Court case, the court held that photographs are in fact protected by copyright. So pretty much everything that is in the list that I provided that's protected by copyright, there's been some case, as you can imagine, that was litigated whether this thing was actually protected. Photographs are protected as long as they're original. We already know that they're in a tangible format, but if it's original. Is your hand up?
No, sir.
Another case, Bell produced mezzotent engravings based on public domain work. Mezzotenting involves some creative, not a lot, but some creative execution. Catalda used a lithographic process to copy those engravings. He was sued for copyright infringement. The Second Circuit, again, this is generally in New York, but not always. The Second Circuit is a really important circuit when it comes to intellectual property law cases. The Second Circuit held that a copy of something in the public domain is copyright protected only if the author actually contributes something original, something of their own that was original. Generally, public domain matters. If it's in the public domain, it is not protected. But in this case, the court held that if there's something that's original that the author added. But here's another one that tells us the public domain works clearly or not protected. This one, Bridgman legally marketed artwork reproduced, reproductions of public domain work. So he took work out of the public domain and reproduced it. Richmond created transparencies of those works, and Corel marketed software and CD collections using those transparencies. Richmond sued for copyright infringement. The court held that there was no protection available for works in the public domain that themselves are not protected. So if something's in the public domain, and if you're not adding anything creative, anything of your own creative, it can't be protected.
So in the last case, it was more like the technique that he had was creative.
The litho, the different type, the tinting.
The tinting.
It required some kind of creativity, some kind of judgment on his part. He added something new to it.
Wouldn't that be more protection for like the process though? You know, like instead of,
No, in this case, it's the engravings. It's the engravings that are protected,
okay, I see.
not the process. Now, the process could be something, that's another issue, but in this case, it was the actual engravings.
Okay.
Like with all cases, I'll tell you, and you've already had some law, everything in the law really turns on sometimes one word, a few words, but it's like, sometimes it could just be the difference between one little word that could really turn a case on its heel. So here, anybody remember Batman? Oh, you would, because it had new Batman since then. That's right. All right. So the Batmobile, this was a case. DC Comics published, and they were also the copyright owner of the comic series featuring Batman. Tully manufactures and sells replicas of automobiles, including stuff that looks like the Batmobile. DC Comics sued for copyright infringement because, again, DC Comics owned the rights to the Batmobile. Now, what do you think is going to happen there? Again, we're talking about a car. Do you think that that would be protected by copyright? A car? And if so, why? And if not, why not? Before I move on.
Well, I think in this case, the Batmobile was so distinguishable that I think that would make it original, possibly.
It's tangible.
And
Yeah,
it's
and
tangible. Okay.
It's somebody's idea reduced to it's this original format.
Yeah. Well, actually, that's right. Because it's that distinctive. I mean, look at it. So, yeah, Tolia argued that the Batmobile was not copyrightable. DC had no copyright protection because, again, it wasn't really original. The Ninth Circuit, which is where we are, held that the car had a distinctive character, entitling it to protection. So the Batmobile is protected by copyright. The design of the Batmobile. Fixation, and this is when you talk about it being in a tangible format. So when a work is sufficiently permanent that it might be reproduced or communicated. So that's that tangible format. It has to be something that you can touch, that you can perceive, that you can communicate, but it has to be in a tangible format. Original, tangible, original, tangible. I don't know if this case is in there, but Williams Electronics. Williams had 3 copyright registrations for its video game. One covered the computer program itself, and the other 2 covered the audio-visual effects. Without permission, Artec sold a video game that was identical to the plaintiff's. Williams, of course, sued Artec for copyright infringement. The Third Circuit held that video games that repeat themselves over and over again are sufficiently tangible. So the issue here is it fixed? And prior to some of these cases that dealt with computers, people were saying, well, wait a second, if it's in a computer, that's not really tangible. The courts are saying, yes, they are. Those cases, those items are tangible. Which is why with computer software, the source code is protected by copyright. All kinds of stuff within the computer is protected. Now, I will also say, if I have a client that has software, I'm gonna also send them to a patent board, because a patent's gonna protect the software. And actually, it's better if you have both protections if you've got software. But you've got copyright protection and you have patentable protection for the software. My Systems develops and licenses software to its customers. The license permits use of internal information. Peak maintains, I believe this one is in there though, isn't it? Is mine? Peak maintains computer systems for its customers and MI's operating software. Peak services require that it loads MI's operating system onto Peak's customers' computers. MI sued for copyright infringement. The Ninth Circuit held that loading copyrighted software onto a computer's RAM created a copy. So the issue here is, if you save a copy of copyright protected content on your computer in an unauthorized way, you have committed copyright infringement. Now, this showed up, right now it's a little different because most of our software is downloadable. Like Microsoft, anybody use Microsoft products? So I have 365, is it 365 that download? Microsoft, and I think part of the reason they now do this is to ward off those infringers. Because when we used to have the discs, people could share the disc with someone else. Every time they shared a disc with someone else, that was an infringement of Microsoft's copyright, period. In this case, proves it. An infringement of their copyright. But now it's a little harder to do that because you have to download it from their cloud system. But this basically says that if you are creating a copy without permission, it's an unauthorized use.
You see the same thing now with video games.
Absolutely.
They're all turned into downloadables where you can only download or redeem the code one time.
That's
Whereas
right.
you used to be able to burn copies of the discs
That's right.
and replicate it. So it's really interesting.
Yeah. And these technology companies are constantly having to come up with new ideas for the protection of their own work because, well, people are smart. Many people are leaving Apple and Microsoft coming up with these ideas actually to steal content from the very companies they used to work for. So. Excuse me. Baker Selden, I know this is in there. Selden copyrighted a book describing, and this is important because this really talks about the distinction between patentable items and copyrightable items. So Selden copyrighted a book describing his system, his bookkeeping system. Baker sold forms taken from Selden's copyright protected book, but rearranged the columns and headings. Selden sued Baker for copyright infringement, claiming the protection for the book granted the protection for the system. But again, I've already told you that systems can't be protected by copyright. So in reversing the lower court decision, the Supreme Court held that copyright in a book that explains a system does not protect the system. It only protects the expression of that system. So it's the description in the book, but the system's not protected. If that system's going to be protected at all, it's going to be through patent. And honestly, it's not likely that a bookkeeping system is going to be protected by patent unless it's tied to some apparatus, some device. That's what this case is all about. And often I've had people come to me who have a system idea and they want to write a book about the system, and I tell them, that's fine, but just know that system is not protected. It's only the book.
So would like a system be protected? Would an example be like is it like when people use their bookkeeping type of?
Oh, you're talking
QuickBooks?
Yeah, QuickBooks.
Would that be protected? Not likely.
Unlikely.
Now, the system could be protected by patent. I actually don't know if it is. But if you think about it, I use QuickBooks, but I don't use another accounting systems, so I don't know if it's similar. I don't know. But usually the systems and processes that are protected are tied to some kind of device. And we'll take a look at some cases when we talk about patents. Lotus v. Borland. I don't know if it's, I don't think it's in there. Is it? I don't think so.
Yes, it is.
Oh, it is?
Yeah, it is.
So this is the one Lotus developed, and this is an interesting one too. Lotus developed and marketed a computer spread program, as people know, Lotus 123, and they came up with the menu commands: save, paste, copy, cut, and they thought that that should be protected. And the court came back and said, no. Menu commands were not copyrightable because they were part of a system, a method of operation. So, any questions, comments, thoughts? You're looking like you want to ask a question. Ask.
No, I don't want to ask.
Or comment,
I
make
just
a
wanted to
comment, make a comment.
As soon as I saw VCR, I looked at the date
Oh.
and saw that it was 1996.
Oh, you weren't born then. Is that what you're thinking? This is pre-me? Pre my existence? Oh.
No, this is old.
Oh, yeah, it is old.
Yeah, it's
Oh, my God. I know I am.
I remember VCR.
So
No, I
VCR.
remember VCRs too. I mean, I remember recording.
Well, vinyls
VCRs
are back.
and that. Yeah.
So VCR can be back.
And
But I just thought it was-
VCRs are around somewhere. I've seen them. Leave them alone.
I just thought it was funny how in the opinion they're comparing it to the using buttons on a VCR. And instantly when I saw that, I looked at the year of the case and I was like, oh,
Yeah.
1996, that makes sense. Yeah, because pre-DVD or any of that.
Yeah. Old. Look at it. It's not old. It is
Oh,
old.
like-
It is old though. VCR. But again, turntables are back in style. I mean, one of my girlfriends, her daughter is like 18 and she wanted a turntable for her. She just went to college. She wanted a turntable.
That's it.
So,
That's it, yeah. be a DJ.
I have a turntable.
Shit, scrunchies are back.
What's that?
Scrunchies.
Are they? Oh, okay.
My teenagers were.
What does they say? What's old is new again.
Yes. there
Everything, nothing really is so original. Everything keeps coming back. I mean, the truth is, I was thinking recently, the girls might appreciate this, Spanx.
Oh, yeah.
Those are nothing but girdles. When I was growing up, they were girdles. I mean, SUVs are nothing more than a truck and a station wagon combined. So everything gets, it's true. It's like a station wagon and a truck. It's higher up than this. So everything just keeps repeating itself. And interestingly, when we talk about patents, you will know that patents really are all about, for the most part, improvements on something that's already existed. Again, when we talk, patents are not that uninteresting, but I don't find them all that interesting. But, some of the cases that I pulled out for you, you'll see it's really just an improvement on something else. Think about the telephone. Now we have cell phones, but when I was growing up, we had pay phones on the street. Now I haven't seen a pay phone in years. But even the cell phone has been improved upon. Years ago, they were big and clunky, and now we've got cell phones that are computers. So, but again, they have been improving on the original idea of a cell phone. So, what's old is new again. Morrissey v. Procter & Gamble. Morrissey copyrighted rules it used in a sweepstakes contest. Procter & Gamble used a similar set of rules in its marketing contest. Morrissey sued Procter & Gamble for copyright infringement. The court held that the contest rules were not copyrightable because the rules were so simple that they could only be explained in one way. So, again, that kind of goes back to the listings in the telephone book, which we don't use telephone books anymore, but it's the listings, the same thing. It's like contest rules. How many different ways do you need to explain the contest rule? They're not protected by copyright. Brandier v. Cascade Pacific Lumber. So Brandier manufactured and sold wire sculptures as bicycle racks. Anybody ride a bike? So you've seen bicycle racks even if you don't ride a bike like I don't. When it was discovered that a competitor, Cascade, was selling similar products, Brandier filed for copyright registration. Copyright Office denied the registration because the bicycle rack design was functional in nature. Now, usually the Copyright Office doesn't step in and make decisions based on whether something is really copyrightable. They generally don't, unless it's such an extreme case. In this case, I guess they felt it was. The design elements merged with the functional aspect. So in this case, they didn't allow the registration to go through because bicycle racks are functional. It's like there's nothing really creative about that. And you have to they have to be able to function as a rack in order to be a rack, regardless of how creative the design was. So in that case, the court said, it's still a bicycle rack, and there's nothing really so unusual about that. Question, comment?
I always have a comment.
Oh, good, please, help yourself. What's the
In
comment?
the opinion, it just talked about how a reasonable, I guess you'd have to see a picture of it because it says that a reasonable person from an objective standpoint would view this only for one purpose, and I didn't agree with that at all.
Pull up, because I can't get mine because I have this up. Go online and put in Brandier bicycle rack. Let's see if we can see a picture. Yeah. That's the good thing about having access to the internet. Yeah. We can go right in there and look it up. So Brandier bicycle rack. Image. Let's see what we see.
So it's like the ribbon bike rack, is it? That's one.
Well, what I just put up any image. You're gonna look it up and see what it looks like. Let's see.
Is that what the hoopy is like?
Oh, I don't know, put in Brandier and let's see what theirs look like.
That's what,
That's not the one, I just.
Render International?
Put in Brandier and bicycle rack, and see what theirs look like. Cause they thought obviously it was.
I think it is the loop.
Is
It's
it
the one that
still
was-
the one? Oh, it's
I
still
think
the
it's that
loop? Oh,
movie one that
well
you
then
see
no
everywhere.
wonder, it's still the loop, okay. Well, then there you go, that's why the government said, well, the Copyright Office said, no way.
Too many people need to use that, get out of here with that.
It's like, and they wanted to protect that?
Exactly.
They could have more loops, basically.
Oh, well.
But it says in the opinion, since any reasonable observer would easily view the bicycle rack as an ornamental sculpture, and I guess without having seen it, I didn't really agree with it, and I kind of still don't. I don't view that, I mean, maybe it's because of my age, I've seen so many bike racks that look like this. I'm like, that's a bike rack, that's not a piece of art.
Not really, I
But
can
that's what the government's saying, that it's not protected because it's just, well, in their case, they're saying because it's functional.
Because it's functional, correct.
Yeah, for them, that's why it's not protected, really, in this case, it's because it's functional.
Okay.
But a bike rack is a bike rack. I mean, how many different ways can you, I mean, I don't ride a bike, so maybe it's hard for me to identify that. So how many different creative ways can you make a bike rack? They all look the same on the street to me.
have holes.
I mean, they have loops and, I don't know. Okay, the other, speaking of what can't be, and so fashion can't be protected, except, there's always some exception, except designer sketches, so again, sketches, artwork, photographs, if you're taking a picture of the fashion, fabric fabric and lace. Sometimes that can be really creative. Appliques and imprints, jewelry can be protected by copyright, and ornamental elements. And this is important because the Supreme Court spoke a couple of years ago on a big case that dealt with fashion. And we'll do this and then I'll put you on a break. This is the test that the Supreme Court used. This is back in March. They held that a feature incorporated into a design of a useful article, useful functional article, because a piece of clothing is functional. It's a useful article. Is protected if it can be perceived as a 2 or 3 dimensional work of art, and if it qualifies under the pictorial category of protection. So with that in mind, the case was Star Athletica v. Varsity Brands. This was the issue. Those are, what do you call it, cheerleader uniforms. So in this case, the Varsity Brands, the country's largest cheerleader uniform manufacturer, sued Star Athletica for copyright infringement of its designs. One's on one side, the other's on the other. The competitor counterclaimed and argued that industrial designs were not protected. The lower court held in favor of the defendant. The Supreme Court came back. Actually, the Sixth Circuit reversed. And they held that decorative elements, those chevrons on that thing, which honestly, I don't see that as protectable, but obviously I'm the only one. Well, the other side felt that way. But the court felt that those designs were separate from the usefulness of the article of clothing because they were raised and because they were, well, 3-dimensional, but also because they were separate. Those chevrons weren't about the usefulness of the item. The Supreme Court granted certiorari, and again, that was a major case because it was held that the separate ability, and that's the test they use, separate ability, the separateness of those designs is what made it protectable. Fashion generally is not protected, and that's a big issue because fashion designers really want their work protected. But some of you may be aware, after all those award shows, you always see those knockoffs of the gowns that the stars wear. That's how you can see them because fashions aren't protected.
So going back again to brand gear, the fact that the bicycle racks had to be able to function with those kind of loops or designs, whatever, it completely can't be separated. It's a functionality and
Exactly.
Design are
Not like this, where these could be separate. Where's the picture again?
because the design on the uniform doesn't have.
The design, the chevrons can be removed.
Right.
And it still doesn't, and they can be put on, it still doesn't affect the usefulness of the article of clothing. Whereas those loops for the bicycle rack, that's what makes it functional. That's what makes it, you can't take that away from the use. You can't separate it. So the separability test would not apply.
Here, those little stripes don't make it functional. It just
Exactly.
adds to the
It adds, it's ornamental.
Yeah, it's the design of the uniform.
Yeah. So they took it all the way to the Supreme Court and they won. Okay, guys, take a break. So it's 7:30 by my watch. What do your watches say?
7:30.
Okay. So actually, you can come back at 8. You can come back at 8.
You guys gotta get your clothes from.
Oh yeah, this is for, but you don't need these now. This is for, and Trish, you can get yours next week.
Thank you.
This is for the contract class, but we're not gonna do this until
I was
December
just messing with
3rd.
you.
See you back at 8.
I'm kind of
Are you hating this so far?
No, it's
I
good.
like
It's
it.
actually interesting. No, it's
I like
good.
it more than I thought it would.
Yeah, me too.
Okay,
I'm like, oh, that's why. Oh, that's why.
okay.
That makes sense.
Yeah. When it makes sense, you like it.
It still might not be your favorite, but at least it's a little interesting to you, that's
It's off to a good start.
good.
If you don't mind. Just gonna try to finish another case brief.
No, absolutely.
Are you taking it easy on these people, Francine?
After our meeting next week.
Actually, they're very interested, which is
Good.
so wonderful
Good.
to have people interested in IP.
It's a beautiful thing.
And,
I love it.
I'll read the chapter today. Did you get all your homework?
I'm trying. Yeah. It's going.
Oh, you're stupid.
The longest meetings for all.
Criminal is kind of like 2 sentences, and you want me to tell you what the case is
No,
about?
I don't think we should have was getting case.
I don't think we should. I
think
think
this-
that for criminal, we should just do it where it's like this, where we're all just speaking.
Yeah.
Because it seems.
Well, if you look at the other cases, they're actually court opinions. I think this first one is
Yeah.
actually just little bits.
Yeah, they all are. They all. I've done all the reading, and this I'm really excited for this. Yeah. Yeah.
Oh, you do it.
I'm excited for this for Conwell because of everything that's going on right now. So
Yeah.
I think it's gonna be the most, interesting.
Yeah, pretty good. It's one of them, which
But it is long.
Mhm.
It is long.
I thought it was 63.
I did this one first because
Me
it was
too.
the shortest. Then I did criminal. Then I left Conwell till the
Yeah, you
end.
just didn't buy that one.
And then yesterday I looked at at that email that we got from what I did not know we had because although I've been gone a year,
Oh,
that's Saturday
the
enrichment course.
Yeah.
So I was like, wait, what?
Yeah.
How did I
Learning
get
right
for Saturday?
meetings, motions.
Yes. But I'm happy to do that. It feels good. I hope you guys don't mind me cutting into your little group here.
Which Claire couldn't make it. I don't know what she's up to nowadays, but she's doing her thing.
There's somebody else.
Actually, it's right.
I think one of the cases I got, I'm okay with. The other one I was like, hey, for Conlaw. I got Hastings, United States versus Hastings, and then I got Oban versus Defenders of. I know Isabel over there.
Have you heard the
Playing Happy Go Lucky with my name, both of you.
like? Well, I didn't hear the first part.
He said that you made, we're talking about the list.
Mm.
He says like, such a weird, both playing Happy Go Lucky with my name on that list.
Can you explain?
What list is this?
Just for cases.
Well, I know you guys have a lot of work in your other classes. But those are also the classes that, are required. There are also classes on the bar, most of them.
Con law. Oh my God.
Yeah,
Oh,
they
it's
found
on the
on
bar.
like
When
the
I
biggest
heard,
one.
there's someone like says she's wrong. She's wrong.
I think Veronica, who just took it, said that Tom Law would probably be like one of the most important ones because that's in every bar. That ends in
They're all,
That's
I'll
what
tell you,
this
what, actually,
They're all.
really, contracts is on the bar,
is.
con law's on the bar, property's on the bar, creme pro is on the bar, actually both, creme and creme procedure. And because you're in California, actually, they just recently changed California, I think it's only 2 days now, is that correct?
Yes,
It used to be 3. So you do have wills is on the bar. Trying to think what else. Oh, ethics. Actually, they have, it's everywhere on the bar. So if you think you can get away with not knowing professional responsibility, you're in trouble. It's probably going to be in every one of the essays.
And you can see why when you see all the cases that are coming up and all the
Absolutely.
problems that are coming up, especially even with contracts. It kind of surprised me that it was repeatedly put in there because contracts is like you said, it's in everything. You can't just even when you verbally with somebody make an agreement, it's just everywhere. So
It's
it
true.
makes sense the topics that they're choosing to repeat. It does make sense.
What else? Corporations is on the bar. Trying to think, what else? From first year, everything in first year, evidence is on the bar. Everything from first year is definitely on the bar.
Did you hear that they got the subjects like 3 days before the bar? Well,
How crappy was that?
yeah.
I'm sorry, say that again?
So the state bar had released the subjects that were going to be tested on the essays to certain deans of schools in California, and I guess to make it fair, they sent it to all the bar takers so they knew like 3 days in advance what
This
Well,
was this
you're right.
previous bar.
This is which bar?
The
One that
July.
they just.
The baby bar?
No, the actual bar exam.
They didn't do that with me.
I know.
They let them know what subject.
Well, they messed
For
up
the
and
essay.
they allowed, they
Oh,
sent it out by mistake first
Oh, it
to a
was a
certain amount of
mistake.
people, so
Yeah.
then
Yeah,
they
they
had to.
inadvertently sent it out to like 16 deans of law schools
What a
before the
mistake,
exam.
Yeah.
Yeah. I don't know, it's a conspiracy.
Yeah.
Huh.
Because there was somebody that would say, oh, well, they got, advance notice, so they were more comfortable. But then there was like, well, there must have been other students who had, who knows how long time to study for those, so the curve could have been raised.
I think they're gonna make it more difficult. I don't think that they would have
California
made it.
bar is always difficult.
Yeah.
Honestly,
just
the
raises
pass rate is very low. It's very low. It's one of the, if not the hardest bar in the country, it's definitely up there. When I took the bar, California and New York were the two hardest. New York is my first bar. And California, I didn't have to take 3 days because I was already admitted to New York. I didn't have to do the MBE portion. But boy, but it didn't matter because the practical and the essays were brutal. Actually, lawyers failed that because it's so hard.
Yeah, I hear the PT exam is what gets a lot of people.
Which one is that?
The PT exam, the practical exam.
Oh, yeah. But now you only have 2 days, so it's 1 day of practical and essays, right? And then the MBE is 1 day? Good luck. But once you get it, you'll be grateful and you will work hard to protect it. Honestly, there are so many lawyers that get disbarred, get censured for a number of reasons. A lot of them have to do with drug substance abuse. Protect your license when you get it, guys, because it's harder to get it back, really. Okay, so welcome back, Trish.
Thank you.
Okay, so now we're gonna turn to duration. So how long does a copyright last? It's not a case there. It's not a case. Ask me a question. Take a guess. How long do you think a copyright lasts? And maybe you've heard some things, so what do you think? Take a guess. You're not getting graded.
I didn't know that they had an expiration time.
Oh, okay, well, there you go, that's a good answer.
I was thinking forever.
That's a good answer. Trademarks last forever. Although there's certain things you still have to do. But no, copyrights have a duration.
So every 16 years.
How many years?
16.
How many?
16.
16?
No.
Did you say 16? How'd you come up with 16?
I made it up.
Okay, all right, well, that's a good try. Good, okay, 16 years. No duration. Do you have a,
Let's do a number out.
oh, you guys better remember too to sign, actually.
Oh, yeah.
I don't want you to not get credit here.
70 years?
I know you said you were kidding.
70 years, okay. Anybody else? So no duration, 70 years and 16. I love it.
He just threw a number out there.
Hmm,
That was 8 minutes.
okay, well.
He said he thought it was 8, but he.
Oh, Trish, how do you sign?
Are you serious?
The professor just puts like
Did you
online
really
and your
just see this?
initials.
Okay.
That's a
Okay, thank you.
good though.
Making sure.
That's a good theory.
Terrible.
Thank you. Did you take his name?
Yeah, because it's like races and I want to make sure hers is
Okay. So what do I just do?
online and just like initial it.
Okay.
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 Every 10 years? They like to use those numbers.
Was that solid?
Is it every 10 years?
You want to keep going? Okay, so a copyright today lasts for the lifetime of the copyright holder plus 70 years. So a copyright lasts a long time. It's, up until the time you die, and then some, 70 years. That's for an individual. And that's why there are a lot of copyright cases after someone is dead. Like Prince's estate has been suing people ever since he died for copyright infringement of his music. So it's lifetime plus 70. Wasn't always that, but it is now. It used to be where the copyright was a certain period. It was like 28 years and then you could renew. And then it was, prior to 1999, it was lifetime plus 50 years. But Sonny Bono, who used to be congressman out of this area, but I remember him from Sonny and Cher back in the 60s. When he was in Congress, he actually initiated what we call the Copyright Term Extension Act. And that's where they added 20 years. So where it used to be lifetime plus 50, it's now lifetime plus 70. And he was the one instrumental in that. If it's for works that are work for hire, or if it's done anonymously, there's no name or someone who's already died, then it's 95 years from the date of first publication or 120 years from the date of creation. But for individuals, for our purposes, for individuals, it's lifetime plus 70. And again, if it was published before 1978, the calculations are different. It really depends on the facts, because prior to that, it would be renewals. So, who owns a copyright? Kind of touched on it a little bit already. The general rule of law is that a copyright is owned by the person who creates the work, unless there is a contract in place or it's a work for hire. Now, this is where it gets to be tricky, because a work for hire, and it's actually in the Copyright Act, shows up in one of two ways. One is if an employee is creating a work within the scope of their employment, then the employer is going to own the work. And again, that's a highly litigated area, as with everything really, but in particular that definitely is. So if you're working for someone, and how this could show up is, let's say you're working for someone, and let's say your job requires that you create marketing materials. You created this really fabulous video, showing your company. And let's say you quit, or let's say they lay you off. And you figure, okay, I've created this really beautiful piece. I want the next employer, or I want potential employers to see what good work I do. So you decide to take a copy of that to take and show to these new people. Well, what do you think?
You created copyright infringement because
You created it though.
But you created it for the company that you're working for, not for yourself. So
Exactly.
they own it because you created it for them.
Exactly.
So the interest.
Arguably, that's what happens, that if you create that while you're working for the company, and if you created it within the scope of your employment, that product is owned by the company.
And a lot of employment agreements that you sign too are gonna have that protection.
Absolutely.
And they're saying that any proprietary
Absolutely.
um,
Assignment.
assignment.
You're gonna have assignment documents that you sign.
Exactly.
That's why when somebody comes to me, and I've had many clients come to me who want to create, they want to write books, or they want to do something that kind of relates to their work, first thing I want to see is whatever they have signed at their company. If there's an employee manual, and employee manuals have been held to be contracts, I want to see that. I want to see any memos that they've acknowledged. I want to see that stuff, because 9 times out of 10, the company has had them sign something that has transferred those rights. So that's one way that a work for hire shows up. The other way is if it's an independent contractor. So one of the things that surprises people constantly when I do this for non-lawyers, when I do programs like this for business people, they are always shocked and a little angry when they find out that because they paid a lot of money for that website, or they paid a lot of money for those wedding photos, or they paid a lot of money for that fabulous logo and new brand, that they don't own those rights unless they sign an agreement that clearly said they do. That is the biggest shock almost always when I do a program. People can't, they say, but wait a second, I paid for it. I paid for those wedding pictures. I paid for that. I paid for that website. Well, The Copyright Act says it belongs to the person who created the work. Unless you had something in writing that basically said you don't know, that you own it. So what has happened with many of the people that come to me as a client, most of them don't think like that. And so they've been shocked to find out they don't actually own the rights to some of that stuff. So then we try to go back and get a transfer of copyright. It's not always going to be possible because at that point, the person who created the content doesn't have to do anything. They don't have to give them the rights. They don't have to transfer those rights. Or they'll want to charge them a lot of money to transfer the rights. That's why I say to people in the very beginning, before you even enter into a relationship, have them sign an agreement that gives you the rights to the work you want to have. And that shows up with all independent contractors, photographers, web designers, ghostwriters, I mean, with anybody who's creating content for you. Here's another sticky area, joint ownership. So I'm not a big proponent of joint relationships. I know they exist. I know, we have them. But personally, I'm one of those lawyers who really believes that if you can avoid a joint relationship, you are better off. And if you go into one, you want to be crystal clear as to what the terms are. So a joint relationship, the Copyright Act speaks to that. Under the Copyright Act, it basically says if two or more people enter into a relationship with an intent, and that's a critical word, with an intent to form a joint relationship, then it is a joint copyright relationship. The reason why this is so important is because in a joint copyright relationship, both parties have equal rights. So let's say Brian and Daniel enter into a relationship to create, let's say you come up with a video game. Two of you together, come up with this really fabulous video game. But let's suppose Daniel really isn't doing a lot. Let's say he comes up with the idea, but again, remember, ideas are not protectable. He comes up with the idea, but let's say that, he comes up with the idea, but you're doing all the work. You're doing all the work putting this thing together, but he came up with the idea. Your belief is you're doing all the work, you own this. But you didn't tell him that. And he's assuming because he contributed the idea that, he's a vital partner here. Because nothing's really clearly defined, it can get really messy. Really messy. And honestly, in a case like that, especially if this video game went big and made a lot of money, you guys will be in court. You will be in court, you will, because money's involved. That's the problem with relationships that are jointly tied together, but where there are no clear expectations, no clearly defined terms, and it's not in writing. So with that in mind, contributions don't have to be equal. So even though he contributed only an idea, an argument can be made that that idea really was critical. Again, you'd be in court, but you can make the argument. And you can also make the argument that because you contributed this, that really it was a joint relationship and that you guys intended it to be. Again, if it's not in writing, it creates a lot of problems. So you always want everything in writing. Honestly, that is the first thing I say to any client that comes to me. I don't care what the business relationship looks like, whether it's with a family member or otherwise. if there is any kind of business interaction here, it needs to be reduced to writing. Why? Because number one, it's easy for people to say, well, he said, she said. It's easy for people to forget because we're getting older. And it's easy for one person to assume one thing and the other person to assume something else. So here's a case that involved a joint relationship. And this obviously went to court. So the plaintiff in this case, Mr. Brownstein, wrote computer code that he used in a program that basically identified an ethnicity for marketing purposes for this company. And what they were doing was looking at like using people's names to determine the ethnic background, which is whatever. Anyway, I just met a white girl called Tawanda, so I don't know how they would have figured that out. So really, it's like, okay, but this was the program, nonetheless. The diversity is not the issue here, it's the copyright. So the defendant created rules used in the program. Mr. Brownstein seeks a declaratory judgment. Do you know what that is? Have you gotten to that yet? So you have? You guys know? So a declaratory judgment is where you go to the court and you ask them to rule on something before there's actually a lawsuit. That's all. You want the court to say, yes, this is a joint relationship, or no, it's not, before somebody files a lawsuit. So that's what he did. He sought declaratory judgment to claim that he was the owner, the sole owner. Ms. Lindsay claimed that they had a joint relationship. She also, because she assumed it was a joint relationship, she transferred some rights to a third party with that copyright, which she could do if she in fact was a joint owner. Because if you're a copyright owner, you can do whatever you want with the work. So she's acting under the impression, under the assumption that she in fact has rights in this work. He says, if indeed she is a joint owner, then I want an accounting. So let me stop here for a moment. If there's a joint copyright relationship, both parties are allowed to do the exact same thing. If I own the copyright in the work we created, I could do whatever I want. I could license it, I could create derivative works with it, and so could you. The only thing is, as a joint owner, you'd have to account to the other party. That's all. You have to account to them. So that's what he's saying. If by chance she's a joint owner, then she owes me some money. The court, Third Circuit, held that the computer program, in fact, was a jointly held relationship, a jointly held product. And that they were, in fact, co-owners, which means they both have the right to do whatever they want. And as a result, she needed to account to him for the royalties. This, again, it gets to be tricky because if you don't define clearly the terms of the relationship early on, somebody can go and sell that. They can go create all kinds of product around that, and you don't even have to know until the accounting comes. So again, it's very important. I don't like joint relationships, but a lot of people do. So what I like to really tell clients if they're considering a joint relationship is, number one, they need to be crystal clear up front what the intent is of the two parties. Do they really intend to enter into a joint relationship? Because if they don't, we need to know that. Because if I'm drafting the contract, I need to make sure it clearly says this is not a joint copyright relationship. I mean, I make sure everything is in my contracts. I do not want anybody to have any question. I don't want it to be vague. I don't want it to be speculative. I want them to know this is not a joint copyright relationship. My client owns all rights, title to, and interest in this work. The first thing. And then If it is a co-authored relationship, if by chance it is, there's some questions I want answered. So these are among the questions that I think are really important. One is, if it's going to be a joint relationship, who's going to own the copyright? Now, it could be joint, and maybe the parties don't want it to be where the copyright is owned by both. That needs to be in writing. It's not likely. If it's a joint copyright relationship, it's likely they both want the credit, they both want the money and the benefit. But if not, we want to know that. If one party owns the copyright and the other one doesn't, what will the co-author get? What kind of terms will they get? And there could be a million different ways that pie is sliced, but whatever it is, it needs to be in writing. So for example, let's say the co-author doesn't get the copyright, but they get a great licensing deal. Or they get, maybe a certain amount of money to cover whatever. It can be negotiated in any way you want. I mean, contracts, the truth is, anything is negotiable. Really, pretty much anything and everything. I mean, depends on how much leverage you have. And that really shows up when I'm doing my publishing agreements with clients, because if they come to the table with very little that a publisher is interested in, they're going to get very little from the publisher. But that's with any contract. The more leverage you have, the more negotiating power you have. How will the co-author be paid? Again, assuming that it's going to be a joint relationship, how will the co-author be paid? Or will they be paid? Who has the final say? Let's say if they're writing a book or anything, any creative content. Who has the final say in the work? Who has creative control? Depends. Again, that's negotiable. So see, these are some of the things. Will the co-author get credit? Like in a movie or a TV show, depending upon where people's name are listed, will tell you how much leverage they have. Now, you might not have thought this before, but like when you watch a movie, for example, Tom Cruise, his name is always above the title. You might not have thought you might never have thought anything of that before, but trust me, Tom Cruise is a superstar and he gets money off the top. His name is above the title. If the name is above the title, they are super, super important.
It's more of a comment. Have you seen or have you heard of the new Spider-Man with Zendaya and Tom Holland? Well, Zendaya, I guess, is the more famous one, but Tom Holland is the actor for Spider-Man. And they were doing a poster, and it's funny because it's Spider-Man, and then it has like Zendaya and Tom Holland. And it's funny because he's Spider-Man, and she's Mary Jane.
Well, she negotiated that. Yeah. That's a great point. Believe me, her lawyers and her manager negotiated that because she's a name, and she's young too. So she's bringing in and she's beautiful.
And she's got a new show, so
yeah,
obviously.
But they negotiated because she had leverage. That's how she could get that. Yeah, and here he is with the little one.
Yeah. He's the Spider-Man.
Yeah, he's Spider-Man.
As Spider-Man!
That is a perfect example. She had the leverage. So she got the top billing. And now when you start watching movies, start looking for that. And it also depends on who's on the right side, as opposed to who's on the left side. Yeah.
Or you're right, when you can see when they put all at
That's
the end of
right.
the movie credit where they put all the names, and you see some people like huge letters and then
That's
other
right.
people with tiny letters.
That's right.
Yeah, wow.
Yeah. And you'll see little tiny, and then some people, it's at the very end with really, really yeah.
You're like, did you see that?
I know, exactly. Arlington, because they go, and they're gone, because, but their names are there. So they've negotiated some kind of credit, but believe me, it's so little.
Self-entitlement, right?
But again, you pay attention to whose name is above the title, even whose name is right under the title too, because that's an important place. Sometimes you'll see two names equal. That's not by mistake. So again, those are things to think about. Yeah, all right. So, let's see. And get it in writing. Again, I can't stress, really, I cannot stress enough. Everything from now on, you need to think about for yourself, as you will for your clients, get it in writing. Really, just get it in writing.
And get a copy of the writing.
Of course.
Definitely get a copy of the writing. Some people
course.
say, you keep it, you're good.
Oh, no,
Trust
no, no,
me.
no, no, no. And I must say, women are notorious for not paying attention to these details. Men make the mistake too, but, because men are in court. But women, for some reason, we just don't want to deal with this stuff until it's too late. And I see that in family law.
Oh.
When I was doing pro bono family law, it was very sad how many women in divorce would give up everything. They'd say, oh, let him have it, I don't want to have to deal with the fight. Until he's gone with his new young wife with all the money, and the poor wife who gave up everything is living in a tiny apartment crying about how come she has nothing, because she gave up everything.
Or they come back with a document saying, I don't know what I signed.
Well,
Tell me what it is, and it's like, you just signed over the property
That's
to
the
him.
other one.
Yes.
So,
We get a lot of that.
reading everything before you sign it, make sure there's an agreement in place. Woo, yeah. Okay, termination and recapture. So the Copyright Act provides, there are two different provisions that speak to, after 35 years, a creator who has given up their rights can take them back under certain conditions. So let me just give you a little background here. Going back to the independent contractors, many independent contractors who sign work for hire agreements are small potatoes. There are people just getting started. They just want to get some money. So they end up signing agreements like music because they just want the money. They need the money. And what happens is, in many cases, years later, after the thing that they have given up the rights to has become super, super successful, some of them then want to come back and take the rights back. Now, this is a bone of contention. Personally, for me, I think it's not right. Even though I represent creative people, I still think when you negotiate a contract, you negotiated, and if you didn't do your due diligence, whose fault is that? And so what happens is many of these people, but the courts didn't agree with me, let me just say. But obviously the people who created the Copyright Act don't agree with me, and they feel that because there was an uneven and unbalance in negotiating power, that these people, these independent contractors should have a right, or these creators should have a right to take back their work under certain circumstances. It's not that easy, but under certain circumstances. Now, in some instances, I do agree with it. And there have been musicians that have been able to get their rights back, because back in the day, a lot of those musicians were getting pennies on the dollar. I mean, it's really heartbreaking. Who just won a big case a few years ago? Little Richard was someone. I think I have in here the Village People. But there's some creative people who really, they were actually abused. They were taken advantage of because they were young, they didn't know any better. So the court really was thinking of them, the Copyright Act, the creators of the statute were thinking of protecting these people. So anyway, last year, I believe was the first year or the year before, they were allowed to start taking their work back, some of them. And that's what has happened, and that's what this is all about, termination and recapture, where the contract was terminated and these people were allowed to recapture their rights. So it gives you a little back.
That reminds me of when Taylor Swift was
That's
kind
what I
of,
was
right?
thinking.
That's what I thought.
Say that again?
Taylor Swift, what she was
Yeah, but
complaining
she's,
about right now.
yeah, but in her case, it can't work because she's not even 35 years old. Isn't
So
she?
you have to be at least 35.
Well, the statute says 35 years from the moment you gave up the
I
rights.
see.
So she can't do
So
anything.
that's why she's just gonna rewrite her
Yeah,
songs.
she
all
wants to
over again.
remaster all her music.
So she left her label.
I remember that when she left
That-
Spotify too, right?
She just, and she.
But she's smart. Actually, she's very
Well,
smart.
that's what I said when I heard of her idea, cause
She
I
is
mean,
smart. I think she's very smart, and yeah, she wants her rights back. Essentially, it is the same issue. But she can't do it under this because it has to be 35 years from the time you gave up your rights. But what she's doing is recreating the content.
mhm.
And she's got a big enough following that
Oh,
she will be
yeah.
successful, because she is very
Her
smart,
manager jumped
actually.
on that one
Yeah.
real quick.
So, yeah. But this is different because this basically applies to older artists, because again, it's that 35-year.
So they basically have learned and they know really what the value of their work
Well,
was.
now
They've
they
been able
do.
to see it, so.
Well, this has become a new issue now because of 35 years. So several lawyers have started to publicize the issue. They're starting to really focus on this as a niche area. And so the more people are talking about it, the more these creative people are discovering, oh, wait a second, maybe I can get my rights back. Yeah. I mean, it's actually a good thing when it comes to like the music piece in particular. I definitely agree with it with music. Mhm.
Is it like an all or nothing type of thing? Like either it's terminated and you can't get it back, or if you potentially can, it's all of it, versus like the courts finding like a mutually beneficial solution for both parties where they could enter into like a joint relationship, or is it like an all or nothing, or are there resolutions that are kind of?
What some of the cases that I've seen, it's that combined, it's not all or nothing. Why? Because if you think about it, it would be unfair if it were all or nothing, especially if over a 35-year period, you know, it was developed into something that if it weren't for the person who got the rights, it would not have happened.
Right.
Yes.
Yeah, so I mean, and that's why, in a way, I don't like the idea, except with musicians. I can see that with musicians back in the day. But a lot of others, I don't see it, because if it wasn't for the person who developed it, then
Nothing would have came
like
of it.
movies, I don't necessarily agree with it with movies. Because the studios built this whole brand, this whole franchise, not the individual who came up with the idea, or, yeah.
Or like the actors that believe that the movies are all about them. It's like, yes, you're a big star, but you're one person, and
Right.
without all the other stuff, the movie wouldn't have been
Yeah.
big. Yeah,
Exactly.
I'm 100% agree.
So it's, you know, it's a balance, but I think the courts do balance it out, you know. But yeah, it's a tough call, but that's actually what's happening right now, because again, 35 years from that time, it's starting to happen. And again, there are lawyers that actually focus on this. So here's a little vignette. I'll read this because it's so tiny. I put this together. So Jane's dad, Benny the writer, was a chart-topping author with 6 New York Times bestsellers to his credit. The books were published between 1979 and 1985, and that's the time frame. Benny was a great writer, but a lousy businessman. He was often overheard saying, "I write and leave the business to others." He was correct, so much so that despite selling hundreds of thousands of books, he made very little money, which actually is not surprising for a lot of creative people, because they don't think like a business person. Like nonprofits, they don't think like businesses, which is why a lot of them go under. Why? Because he was without an agent for the first 4 books and assigned his rights in those books to his publisher. Second, because he granted an exclusive license in perpetuity to his agent for his last 2 books. So he obviously wasn't a smart guy. He may have written good books, but he was stupid when it came to business. I would have never let a client do this. Number one, the word assign, it means he gave up all the rights in those works. And he gave an exclusive license. Exclusive means he couldn't even do anything with it anymore, because literally that was like an assignment. So Jane is a junkie with money problems, never one for work, and always looking for a quick fix in more ways than one. She read somewhere on the internet that she could get back the rights to her father's books. He was her father. She's going to try. So, do you think she could have done it? Potentially. Potentially she could have. Depends on what his will said, if he was smart enough to have a will, but even if he wasn't, intestate, his daughter, unless there was a wife, would have gotten the rights. But there were no rights really because he gave up everything. So the Copyright Act again provides in two separate provisions from that after 35 years from the date of initial transfer, again under certain conditions. It's not blanket, it's not always, it's under certain conditions. The owner of a copyright or her heirs may, and the operative word is may, have recapture rights. So she might have, depends, she might have. Those are the two provisions, you can look them up if you're interested, Section 203 and Section 304. Any transfer executed on or after January 1st of 1978 is subject to termination under the Copyright Act. Section 203, unless the work was a work for hire or the transfer was through a will. And any transfer made before 1978 is controlled by Section 304. So after 1978, Section 203 controls. Prior to 1978, if there was a transfer, it's Section 304. Bottom line is, in some cases, someone can get their rights back in certain cases.
What would be the difference between a work for hire and employment? Is it just that they're, like the independent contractor just hired for this specific job, and then employment is someone that does it regularly?
So there is a clear distinction between an independent contractor and an employee. The tax code talks about it, the Copyright Act talks about it. An employee is somebody with whom you control what they do, dominion and control. They're like, I think the IRS, the Treasury Department has like 20 factors, is it 10 or 20, something like that. But clearly it's about dominion and control. If it's your employee, you get to control what they do, you control the implementation of their work, everything. And you take out taxes. An independent contractor comes to the table prepared already to do the work. They are responsible for the instruments of their work, their computer and things like that. And ultimately you don't control what they do. You may give them an assignment, but you don't control how they do it. And you don't take out their taxes. Actually, you give them a 1099 form. And that actually is a very highly litigated area. A number of years ago, and I'm thinking it might be like around 1997, 1998, Microsoft had a big lawsuit against it. There were several of its independent contractors that sued Microsoft for back pay, for vacation pay, for stock options, for everything Microsoft gave to its employees. But these are people that were considered independent contractors, and there was a work for hire agreement in place. Court said, there was a misclassification here, and these are employees. Microsoft was blown away, but they lost big time. I can't remember all the details, but I can tell you, I'll get to you in 1 second. Among the reasons that the court found that they were employees was because how Microsoft treated them. You know, you have to be so careful when you have independent contractors. You cannot treat them like employees. Microsoft invited them to the same company parties and events that employees would come to. They had extensions on the telephone where people could get to them directly. I mean, there were a number of things that Microsoft did, which is surprising as big as they are. But there are a number of things they did that actually treated these these workers as employees. So they crossed the line, and the court found, okay, you crossed the line, you gotta treat them like employees. So they had to pay back salaries, they had to give them stock options, it was unbelievable, all because of misclassification. So I don't do employment law, but employment lawyers will tell you, you really have to be very, very careful about that, because there is a difference.
I was just gonna expand on that. It's gotten a lot more liberal too over like the last 20 to 30 years. If you talk to any employment lawyers, there are new Supreme Court cases coming out all the time on employment law, talking about the factors and how they're getting more blended into protecting independent contractors. You see all these agencies, like the California Labor Commissioner's Office that protect, it's an employee protection agency, but now you're seeing some of those protections being extended to independent contractors, and the more the years go by, the closer we're getting to independent contractors having the same extent or the same protections that are offered to employees. It's crazy.
And California traditionally has been a very employee-friendly state. That's even changing. You know, I find many of the rules that have gone into effect, and I know some of them only because they cross into IP, they have become more business protected rather than employee protected. So, you know, depends on who's in office also, you know, things change. But in New York, when was it? It was a number of years ago, not too many years ago, New York passed something that, I'm trying to remember exactly what it was. It had to do with independent contractors. I can't remember right now. I just lost it. But it's, interns. It has to do with interns. So there was a time when interns, you know, you bring an intern on, you don't pay them, you just give them the experience, and they should be grateful, which I still think, personally, I didn't even like the New York law, but whatever. Now, interns in New York rose up and they got the court, they sued employers because they felt like they should be paid for the work they were doing. And they won. Now, I don't know, I have an issue around that because I think, to me, that's part, and I know you guys are part of the millennial group, but I just think that is, you know, it's like, hello, some of us have to work to get to a different place. If you take on a free, an internship, you know what you're doing. You're trying to get experience. If you want a real job that you get paid for, go get a job. But obviously, New York courts didn't feel that way. They sided with the interns and felt that they should be paid. So now, in New York, if you bring on an intern, you better make sure you're paying them. And you better make sure you're paying them what you would pay anybody else. And so the idea of hiring interns might become less and less of an option for that very reason, at least in New York. And I'm sure it'll come here too eventually. I can see that actually happening. Anyway, but this is all a part of copyright law. You know, this is what makes it interesting because every day there's some issue related to what we do in this area. Oh, here's the one about Village People. So the lead singer, so Victor, I'm sorry this was so small, I usually try to split them up, but I'll just read it. Victor Willis, the original lead singer of the Village People, was hired to translate or write new lyrics for musical compositions owned by the publisher. Willis transferred his copyright interest. Again, he transferred because, again, these guys are young. You know, when they started, they just want to get some money. They write this music for other people. So he transferred his copyright interest in 33 musical compositions, sheet music, to this organization called Can't Stop Music, which then assigned its rights to the publisher, the music publisher, that is. And music publishers are the ones that own the rights to the sheet music. He agreed to a percentage of the gross for each composition, He was credited as a copyright owner on the copyright registrations. In 2011, he served a notice of termination under Section 203 of the Copyright Act. And again, that's prior to 1978. Concerning his interest in the 33 works, the court granted his motion to dismiss and held under Section 203, a joint author who separately transfers his copyright may unilaterally terminate the grant. So he alone was able to terminate and recapture his rights in those 33 pieces of music. Again, when it comes to musicians, I actually don't have an issue with them getting their rights back, because when they write this music, most of them are hungry. They're young, they're hungry, they're poor, they just want to get some money to survive. But again, on the other hand, I have to say too, that in a lot of cases, this case was different because he was part of the group and he actually helped to make the music successful. But for some people, they don't contribute to the success of a work. But these musicians, I'll tell you the other thing about Taylor Swift, and a lot of the new artists now, they are writing their own music. And that is the smartest thing they could do. Not only do they write their own music, but they perform it. Dolly Parton has made a fortune because she wrote music for a lot of the people that, we wouldn't even think she wrote music for. Carole King was another one. Carole King wrote a lot of music for early Motown people. A lot of the people that write music make the money. They're the ones that make the money. So anytime an artist is writing their own music, believe me, they are getting a bite from both ends of the pie. We will talk about how to protect copyrights, and then I'll let you go, because it'll be about that time anyway. So when someone comes to me and they are thinking about protecting their content, there are several things that I talk to them about, and this is more of a practical conversation right now more than the legal. I mean, it is legal, but it's mostly practical as a lawyer. This is what I would talk about if I'm talking about it with a client. So the first thing is, it's really important that these people view their work as a valuable asset. I mean, it's amazing to me how many content creators just don't think of their work as valuable. So if you don't think of it as valuable, then how would someone else, or why would someone else consider it valuable? So the first thing is to actually think of it as a valuable asset. And copyrights are assets. They are transferable as assets. So like in a will, excuse me, when I'm drafting estate planning, estate documents, I make sure I include in the transfer of assets any intangibles, which would include copyrights, trademarks, patents, things of that nature. So the other thing is to use the copyright notice symbol. Now, it's not required. I put 2017, you can put any date, well, I'll get to that. So it's not required. As a result of us becoming signatories to the Berne Convention, however, it's a smart idea. Why do you think it's a good idea to have the copyright notice symbol on work?
It gives notice to others so that they can't claim they didn't know.
That's it, there you go. That's it. Even though you don't have to have it, you should, because of that reason. It gives someone else notice and they can't come back and claim I'm an innocent infringer, because that is a defense in some cases, innocent infringement. But they can't claim innocent infringement if they had notice. So if they're going to have the notice symbol, there are one of three ways that it needs to be done. First, the components of notice are copyright, either the word or the abbreviation, which is COPR, or the C in the circle. You don't need all three of those. It's either the word copyright, the C in the circle, or the abbreviation. And then it's the year of first publication. So if somebody's creating something this year, it's gonna be 219. And then it's the owner of the copyright. So the owner could be an individual, it could be a company, but whoever the owner is, it's their name that's gonna go there. I also sometimes include all rights reserved, but you don't have to, but I do sometimes. So it's the word copyright or the abbreviation of the C in the circle, year of first publication, and the copyright owner. That is the proper notice. If you're gonna have notice, it needs to be proper. The other thing is, in terms of how do you protect the copyright, you be mindful of the contracts you sign. Really, I mean, I cannot tell you how often I have seen a contract where somebody's given away their rights and didn't even know it. Why? Number one, because they didn't read the agreement. I mean, that's number one, which just blows me away that adults don't do that. But then they read the agreement and didn't understand it, but they signed it anyway. So, again, inadvertently giving away one's rights in an agreement happens more often than we can imagine. And actually, I would venture to say, and you don't have to answer, that you guys all have signed agreements without reading them. Whether it was a rental agreement, whether it was, you go to a doctor's office and they have you sign stuff. I won't ask you who has or hasn't, but they hate me when I come in because I stand there and read everything first. I would never sign anything without reading, ever. But, I mean, I've learned the hard way. I remember years ago, before I left New York, I'm originally from, well, I was raised in New York, I'm from New York. And I remember before I left New York, I had a procedure with the doctor. And they had given me this agreement that they give everybody when you first come to the doctor's office. So I'm sitting there reading it, and the doctor's like huffing and puffing there. And it's a good thing because I noticed, I was supposed to have a, like I said, a procedure. I noticed there was language that suggested that they could substitute my doctor for a nurse practitioner or another doctor. Well, excuse me, that wasn't gonna happen. I mean, this is the one I wanted. So I proceeded to cross that out. He's sitting right there in front of me. I take a pen and I literally crossed that out. And he said, what are you doing? And I told him, I said, no, you're the one I want. Well, he wasn't gonna argue with me, but I crossed it out. I thought to myself though, how many people realize that's what they signed? And it's been in every agreement that I've ever had to sign with a doctor when I've had a procedure. But I thought, how many people have signed that and didn't even know what they were signing? Or how many people have signed car rental agreements and not known what was in it, or not paid attention to the amount? I remember once I was renting a car, and there was someone next to me screaming at the agent, saying, I didn't agree. They were returning the car, and they said, I didn't agree to this amount. How come you whatever? And the agent said, but sir, you signed the agreement. He said, I don't care, that's not the amount I agreed to. I said, but sir, you signed the agreement. This is like he's returning the car and he's now worried. He said, but you signed the agreement. Of course, the guy ended up having to pay it because he signed the agreement. But what it reminded me of is, again, how often people don't read agreements they sign and then after the fact want to complain. So, inadvertently giving away their rights in agreements. So, if you're going to protect your work, again, it's not required that you register it, but my Lord, it's absolutely worth it. Why? There's some benefits to copyright registration and registration with the U.S. Copyright Office. So here's some of the benefits. Among those, you receive a certificate from the government, basically saying that you have registered this work. It establishes a public record, so anyone who's doing a search will see that you actually have this copyright registration. You have the right to use your work nationally. Now, it doesn't apply outside of the United States, but if you have a copyright registration in the US, it makes it easier if you want to register your work in a foreign country. You have the potential of getting statutory damages, which could be pretty high. You could get treble damages, up to treble damages. You can get attorney's fees, possibly, all if you have a registration. But the most important thing, I think, is you have the right to sue. Now, some people will say, but wait a second, I heard that you have a copyright the moment you reduce that work to a tangible format, that original work. So why do I need to register? Well, you don't have to, but again, you can't sue without that registration. We're going to talk about a case next week. I don't think I'm doing it now. Oh, we're going to do it right now. Case that just came down from the Supreme Court. This is the case called Fourth Estate versus WallStreet.com. Up until this case is decided in July, this July, there was a split in the circuits, and it goes back to how one court can decide one way, another court can decide another way. There was a split in the circuits as to what was required to sue for copyright infringement. It was either some courts, like the Ninth Circuit, held that as long as you filed an application, you can sue. But other courts, like the 11th Circuit, held that no, the statute requires a registration. But on the Ninth Circuit felt registration, as long as you've got the application in, that's good enough. The Supreme Court finally, thank God, resolved this issue. A lot of copyright lawyers didn't like the answer. Personally, I did. The Copyright Office held, or rather the Supreme Court held, you have to have a valid registration, not just an application. So the defendant in this case moved to dismiss on the grounds that the plaintiff had no valid registration. And under Section 411 of the Copyright Act, it said a registration was a precondition for suing. Plaintiff alleged it filed applications, but it didn't have a registration, but it filed the application. The Supreme Court came back, that was the lower court. In 2017, the 11th Circuit held that a registration, that a lawsuit could only be filed when there was a valid registration. The Supreme Court affirmed that decision. So, the bottom line here is the only way you can file a copyright infringement lawsuit is if you have a valid registration.
How important do you think the fact that they filed the registration right before the suit? You know, if the application for the registration, say they had filed it a year or 2 years prior and it was held up for some reason.
Well, that's actually kind of what happened. The Copyright Office hadn't gotten to it. But still.
So it wasn't right before the litigation?
No. But that could happen if you, so here's what potentially could happen. Let's say, or even if there's an infringement, let's say there is an infringement, or you think there might be right before, you can file an expedited application and you can get your registration done soon. Usually it takes the government about 6 to 9 months for filing, but if you wait till the last minute, you can pay like $900 to get it done like in a few weeks. You can get that done as long as you get it done before. And if you get it done after, let's say, an initial infringement, actually what this case has said is if it's a registration and you win, you can recover for an infringement that occurred before and after registration. That's what this case also had. But the key is to get the registration. You know, when someone comes to me, I just actually try to convince them that if they want to really get the protection that they want, they need to register. You don't have to, but it's like if you've got all this valuable content, why not? I had a situation last year with a very famous author. There were two of them. They were joint owners. And honestly, I'm just surprised these guys just didn't register their work. And again, that reminds me of how creative people are not always smart business people. Somebody tried to, it was arguably a joint relationship, which it wasn't supposed to be. They didn't have anything in writing, or actually what they had was a piece of garbage. They had some contract they pieced together. It was a piece of garbage. And so they wanted to get their stuff registered right away before they knew the other side was going to sue them. So I filed for them. I filed 6 copyright registrations, and all 6 had to be expedited. So we're looking at like $900 for all 6 of them, and that wasn't even my fee. But, you know, they waited to the last minute, they had to do it, they were willing to pay. But you could avoid that if you register right away.
What is the standard fee then to register?
Standard fee is 45. I'm thinking now 45. If it's like a single, it's not expensive. If you're doing it yourself, it's really not, it's not like a trademark that's expensive or a patent. It's like 45 or 55 if you've got a series of things, but it's not expensive.
You have to turn in a sample to her?
Oh yeah, you have to, well, it's not even just a sample, you have to submit what it is you want protected.
Okay.
They have to.
So if you, so if you wanted to do like a series, like say you were copywriting your blog posts for original content, and you want to do a series of them, you could pay a little bit more
55.
to get all of them done.
Well, there's some rules,
Right.
but there's a way that you could get a lot of them in, like photographs. I think it's now up to 250 copies of photographs. You can put it under one application. The problem there, though, is in the events, like if you put everything under one application like that, a series, and you don't label each one, if somebody tries to use your work, it's a little harder for you because it's all under a blanket cover rather than each individual that's clearly identified. You know, what I try to do is if a client has a series of things like that, I try to identify everything individually, even photographs, because if somebody copies one of their works, at least we can say, this is exactly what they copied, and this one is protected, not the bucket that covers everything together. But yeah, it's cheaper. You can put a lot under that cover. Then it's $55. Still, it's cheap. If you're doing it yourself, but you have to know what you're doing. That's the thing.
Right.
But yeah, it's not like a trademark. Trademarks are expensive. Patents are expensive. How to register? This is if you do it by paper, but the Copyright Office is really moving away from paper, and they try to discourage paper. So it costs more, actually. Oh, maybe, is it up 85? I have to check. But they discourage, because it's paper. So they discourage you from filing by paper, just like the Trademark Office. You'll see when we talk about that, they really discourage paper. They charge you so much more. I mean, we'll get to that, but all of these organizations really want you to do everything online. And it's easier for them, but it's easier for us too. I mean, I don't file anything by paper, nothing. Everything I file online. And now, actually, the Trademark Office, as of, it's coming up, I think the date, I think it's October, literally, you have to file everything online. So if you're doing it by paper though, again, it's more money, and you have it would be one of those forms. TX would be if it's a literary work, like a book, an article, a blog post. SR would be for sound recording. VA would be visual art, so it could be sculpture, jewelry, something like that. It could also be pictures, logos. Well, logos you may not be able to necessarily protect, but a logo you would protect as a trademark. But it depends, you know, there are always extenuating circumstances. PA would be, like pantomimes, choreographed work. SE would be series, so like newsletters, things like that, series. And then you would include a cover letter. I always tell clients, this is back in the day when we actually were doing it by paper, I would always have them include a stamped self-addressed envelope. So the government would stamp it the moment they got it. And at the time, we could use that as proof of registration. Now we can't. You know. And a non-refundable deposit. And they'd send it to the Copyright Office, which is in the Library of Congress in DC. If you ever get to go, it's actually an interesting old library. It's huge. And the Copyright Office is part of it. Or you do it electronically, which is how we do it today. And that's, I think it's now 45, it still could be 35, but 55 would be if you've got like a series. And it's copyright.gov. And this, how many of you have ever heard of the poor man's copyright? It's a good thing. So I think it was started by some poor author who couldn't afford or who didn't want to pay to register their copyright. So they started telling people that if you mail a copy to yourself, that's valid. Well, that's not valid, because if a copyright registration is required for the kind of protection you really want, mailing it to yourself doesn't really prove anything. Doesn't prove anything anyway. You could mail anything to yourself and claim you own it. But that's what people believe. I see it all over the internet, poor man's copyright. Anyway, no such thing. So I'm going to end there. Any questions about what I know it was a lot we talked about today.
It was interesting. It was interesting.
Yeah.
Well, next week we're going to just focus on infringement. We're going to talk about infringement and fair use, which is an exception to copyright infringement. So we're going to look at some more cases, but mostly it's going to be focused on copyright infringement, what constitutes infringement, and that's it.
Well, thank you.
Any
Yeah,
questions,
thank you.
comments? Okay.
Thank you.
Well, thanks, guys.
And then Professor, email you for the slides.
Oh, yeah, absolutely. Actually, wait till after this, wait till after next class, because I have them all together, copyright. Yeah, but I'll definitely send them to you.
All right. Good night, guys.
Good night.
Bye.
Night, Trish.
Night, Daniel. Night, Brian.
Good night, Trish.
Night, see you next week.
See ya.
Okay.